Do you remember how the Australia Acts came into existence? After the enactment of the Commonwealth of Australia Constitution in 1901 and the Statute of Westminster Adoption Act in 1942, the UK Parliament could not legislate for Australia anymore. However, because of the operation of the Colonial Laws Validity Act of 1865, it was still possible for the British Parliament to legislate for the states. We explained this dynamic in our previous video, the one that is appearing here on your screen. To solve this issue, that is, to make sure that the UK Parliament could no longer legislate for the Commonwealth or the states, there was the enactment of the Australia Acts. And we call them the Australia Acts because there were 8 other laws that had to exist before the Commonwealth finally enacted the Australia Act of 1986. But you're asking, what has this to do with section 5138 of the Constitution? Everything. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will finally understand section 5138 of the Australian Constitution. I will divide this video into 3 parts. First, let's look at the original meaning and the intention behind section 5138. Then we will briefly see how this section operates in practice by looking at how key it was for the existence of the Australia Acts. And then in the final part, I want to ask you some hard questions about this section and its possible operation in the future. So stay until the end and I can guarantee you will not regret it. Okay, first things first, let's start by reading what the section says. Section 51 says that the Parliament shall, subject to this Constitution, have the power to make laws for the peace, order and good government of the Commonwealth with respect to the exercise within the Commonwealth at the request or with the concurrence of the parliaments of all the states directly concerned of any power which can at the establishment of this Constitution be exercised only by the Parliament of the United Kingdom or by the Federal Council of Australasia. The idea behind this provision, as expressed by Sir Samuel Griffith during the proceedings of the Constitutional Convention in 1891, was that a provision should be made in the Federal Constitution to enable the Federal Parliament to exercise with respect to Australia those powers with respect to individual states which at the present time can be exercised only by the British Parliament. It would be entirely inconsistent with the whole theory of what we propose to do if a state of Australia, desiring to alter its constitution, had to go past the federal government to the British Parliament for the ratification of that alteration. So the idea was to allow the states to ask the Commonwealth to legislate for them with respect to certain powers they did not have. It would be terrible for the states to keep on asking the UK Parliament to legislate for them on such matters. So, to make it easier and to keep it home, it would be preferable for the states to ask the Commonwealth to legislate on their behalf in these matters. As Quick and Garran comment, subsection 38 seems to relate to powers that are for the peace, order and good government of the Commonwealth, but that were not given expressly to the Commonwealth elsewhere in section 51 or in other sections of the Constitution. And more. These powers are not given to the states either, because otherwise, well, they could refer these powers to the Commonwealth by using section 5137, which allows the state parliaments to refer matters to the Parliament of the Commonwealth if they want to. So these powers belong only to the Parliament of the UK or the old Federal Council of Australasia. Now, since the Federal Council of Australasia was abolished by the Covering Clause number 7 of the Constitution Act, let's not deal with it here. For Quick and Garran, the powers that section 5138 refers to could only be the following. Powers to amend imperial legislation extending to the colonies by paramount force, powers to enact extraterritorial legislation, powers that relate to matters accepted by the constitutions of the states. Lumb and Moens explain these 3 classes of powers in the following way. They say that the first class are those powers of the UK Parliament that, even after the enactment of the Constitution, could continue to bind the Commonwealth Parliament and the states. One such example would be the Colonial Laws Validity Act. Here, remember that we did not have the Statute of Westminster yet, okay? So both the states and the Commonwealth were subjected to the Colonial Laws Validity Act and could not legislate in a manner repugnant to the law of the UK that operated by paramount force. And so it's a typical example of this first class. The second class are those powers to legislate extraterritorially. Neither the Commonwealth nor the states could do that if not by a grant of power by the UK Parliament. However, according to the decision of the High Court of Australia in Port Macdonald Professional Fishermen Association in South Australia from 1989, the expression "the exercise within the Commonwealth" that is found in the beginning of section 5138 refers to the place of the exercise of the power and not the extent and operation of that power. What does that mean? This interpretation basically says that after the Constitution, and considering its many heads of power, it would be possible for the Commonwealth to legislate extraterritorially. And with the enactment of the Statute of Westminster, of course, this wasn't a problem to the Commonwealth anymore. But it remained a problem for the states because of the Colonial Laws Validity Act. The third class of powers that seem to relate to section 5138 are those that were excluded by the constitution of the states themselves. These are things like duties of customs that could not be imposed on goods imported for military purposes, so very specific things. Again, with the Constitution, these things fell into the scope of the Commonwealth's power. And then with the adoption by Australia of the Statute of Westminster, some defend the view that the Commonwealth now had the power to legislate with respect to imperial legislation extending to the states, as long as the states consented to it. In Aroney and Captain Cook cruises from 1985, some members of the High Court of Australia even said that after the enactment of the Statute of Westminster and its adoption, the Commonwealth Parliament had the power to repeal imperial legislation applying to state. Okay, so we understand the kinds of powers that are involved, so what is the applicability of this section now? Is there any power that still falls within the scope of this section? I'm gonna let the High Court of Australia answer that question for you. According to the High Court in Port Macdonald, the effect of section 5138 is to empower the Commonwealth Parliament to make laws with respect to the local exercise of any legislative power which, before Federation, could not be exercised by the legislatures of the former Australian colonies. The issue here was with the powers that the states did not have before the enactment of the Constitution. So the court defended a broad interpretation of this section moving forward. Their honours gave two reasons for this broad interpretation. First, it is clear that one of the functions which paragraph 38 was intended to serve was that of plugging gaps which might otherwise exist in the overall plenitude of the legislative powers exercisable by the Commonwealth and state parliaments under the Constitution. Secondly, the grant of power contained in paragraph 38 does not represent the enhancement of Commonwealth legislative power at the cost of the diminution or potential diminution of the effectiveness of state legislative power. The sense that the High Court gave to this section seems to be that this provision helped organize the Federation and fill the gaps of the powers that needed to be exercised, but couldn't be because they were neither granted to the Commonwealth because the Commonwealth didn't exist, nor continued with the states because they couldn't exercise these powers before Federation. So let's look at the enactment of the Australia Act by the Commonwealth as an example of an application of this section. Just hang on a minute. Before we do that, why don't you click the like button and subscribe to our channel? And look, if you hit the bell icon, you'll be notified when I upload a new video. And you can also become a member of Aussie Law. It is as easy as clicking that join button over there. This is great for those of you who want early access to the videos and actively engage with our community and help us do what we're doing here at Aussie Law. So the enactment of the Australia Act is the typical and clear example of the operation of section 5138 in practice. As I said in the beginning, there were 8 laws by different parliaments that had to exist for the final product, the Australia Act 1986 of the Commonwealth, itself to exist. According to section 5138, each of the states legislated an Australia Acts Request Act in 1985. So there were 6 Australia Acts Request Act enacted, each by a different state with substantively the same thing: a request for the UK Parliament and the Commonwealth to legislate on the state's behalf because of their lack of power to do so. And then after the 6 laws, there was an act of the Commonwealth requesting and consenting to the enactment of the Australia Act by the UK, because this was required by section 4 of the Statute of Westminster. And the title then of this law was Australia Request and Consent Act of 1985 by the Commonwealth. With all parliaments in Australia, both at the states level and the federal level, requesting and consenting to the new law, the UK Parliament enacted its own Australia Act, the Australia Act 1986 of the UK. And so with all of that, and finally at the last stage, they want to remove all doubts about the validity and enforceability of the Act in Australia, the Federal Parliament, the Commonwealth Parliament, enacted its own version of the Australia Act, which is virtually a copy of the provisions of the UK Act. This process for the enactment of the Australia Act 1986 by the Commonwealth then was the result of the operation of section 5138. The states requested it, the Commonwealth concurred to the enactment of the law, and more, because of some doubts about the operation of this section that had only been used once before, the Commonwealth, still under the Statute of Westminster, requested and consented to the UK Parliament legislating on their behalf. Alright, I hope that became clearer for you, not only in terms of the operation of section 5138, but also about the process involved in the enactment of the Australia Acts. But some interesting questions can come out of section 5138. Even after the Australia Acts and the Statute of Westminster, some scholars still envision its usage for this subsection of the Constitution. So let's look ahead and think about possible operations of this section. For example, is it possible to alter the covering clauses of the Commonwealth of Australia Constitution Act according to this section? Since this is an act of the UK Parliament to which neither the Commonwealth nor the states had the power to legislate about before Federation, is it possible for the states to request the Commonwealth to change it? There has been a lot of discussion in this regard. Big names like that of Professor George Winterton argued that if Section 128 could not be used to alter the covering clauses, Section 5138 could definitely do the job. But other big names like that of Professor Sawyer or Professor Moore, they disagree. And look, since we are discussing the covering clauses in the Act of the UK Parliament, why not ask whether it's possible to amend the preamble to the Constitution Act? I mean, if we consider the preamble as part of the Act, would it be possible to alter it now under Section 5138? These are difficult questions, but very interesting ones. So I'll come back to these in my next video. Up next, I will talk about the possibility of creating or amending the preamble to the Australian Constitution. Make sure you are subscribed to Aussie Law so you don't miss this video. And I hope to see you again soon. Until then, ciao.